Good afternoon. Now that we're back into this next session, I have our guest speaker, Roscoe, that's here with us, going to tell us more about how to protect ourselves, how to get our money faster, and how to be more successful in our construction business. So Roscoe, thank you for being here with us today. I'm excited that you're going to show us what we can do to protect our assets, protect our businesses from lawsuit, even when we're trying to collect on projects that we put in our hard work, our hard efforts and time. And it seems like these clients, owners may not want to pay in an expedited manner or in a manner that we agreed to. So thank you for joining us today. I know everybody that's here watching are sitting on eager anticipation on all the tricks, all the tools, best practices that's going to help them succeed. So again, Roscoe, thank you for being here. And we want to just hear more about you and maybe your experience and the things that you've seen in the industry.
Yeah, thank you for having me, Michael. Obviously, was thrilled for the opportunity to come support. When you asked me to provide some insights, I was glad to do it. And so, I love, helping and giving back. And so, this is what I'm here for. And, for me, I've been in construction my entire life, almost 25 years. I've come from a family of contractors. I'm a general contractor myself and kind of worked my way up the ranks, from a concrete laborer to field superintendent, a project manager on, all different, types of projects. And, when the economy slowed down, I said, always wanted to do law. And so I went into law. Now I am a partner with Adams and Reese. I'm a board certified construction lawyer. And I find that, those experiences, pulling a come along or tying rebar, really helped me, navigate these, what are often complex construction issues. Mm-hmm. I think this, construction has really evolved since, even the 90s, we're becoming more advanced, there's a lot more technology involved, a lot more paperwork. And so what we see on our end is a lot of potential pitfalls, if you will, where contractors, can easily, slip up. And, one of the things, I really like, doing is preventing accidents or preventing, expensive, breaches of contract, and a lot of that starts in the beginning. It sounds great. Oh, you got these really big projects and, there's something that goes along with that. If it's a higher dollar value project, then the mistake is probably going to be a higher dollar value mistake. And so you want to be sure that, you really understand, what you're signing up for.
Gotcha.
In the beginning. And so that's a little bit about me. I'll go right into, some of the things that we see from an attorney standpoint that often, trips up our clients.
Sounds good. Let's do it.
So some of the key contract provisions are, your risk of loss provision. Many contractors will never, ever look at the contract when they're bidding the work, not realize that, hey, I've signed up for a contract where I have assumed the risk of loss on that project through the end of the project, whether you're the concrete guy, let's just say you're doing ditches or whatever on the project, and that ditch gets washed away by Hurricane Michael 6 months down the road in the project, you're off the project.
Right.
You've got this provision in the contract where you've assumed the risk of that loss. And now guess what? You've got to go back out there and replace that.
Okay.
I see that as being a potential issue and folks not actually looking at the insurance requirements on the project. Builder's risk. Is there a builder's risk policy in place? Who's required to obtain that builder's risk policy? How much is that going to cost? What's it going to cover? Is there a general liability policy? Do I have the right coverage? Have I actually looked at the policy? The policy is a contract, and many contractors get that accord statement, the deck page, say, hey, it's got $1 million worth of coverage. I'm good. You got to actually pull back the four corners of that policy and really understand, because that's where the meat of that policy. So that's a really common mistake that we see. Indemnity, indemnity language in the contract, your obligation to pay for another another party's.
Well, hold up, because I can hear somebody in the room like, man, he just using all these big words. I have no clue what indemnification or indemnity is. Can you explain indemnity?
Yeah. Indemnity is essentially, I'm gonna give you an example. If I go on the project and one of my subcontractors causes damage to, someone, either the contractor's work or someone else's work, that contractor is going to say, hey, this is your you did this was your sub. I need to be compensated for the loss that I experienced as a result of you. That's in its simplest form. It's the obligation to pay for another's loss.
Okay.
And so you see these indemnity provisions in these contracts, and they'll be very, very broad. And you'll be indemnifying the architect, the owner, everybody.
So does that mean now I separate responsibility, or does that mean I'm including responsibility?
So it could be both, depending on the language. And that's the key, is to look at the language and to distinguish who you're going to be obligated to indemnify. Am I obligated to indemnify the architect for his own negligence?
That's good.
Am I obligated to indemnify their agents? Or if you're a sub, you want your indemnity, and most times, the contractor is going to require you to indemnify them. But you want to limit it to them. Right. You don't want it to be this whole universe of people to the extent you can negotiate that.
Got it. So if I'm a subcontractor, I want to possibly limit my indemnification to the GC, right? Mm-hmm. And not everybody else that they work for. Right. So that may be one thing I look for in my subcontract. However, if I'm the GC now receiving a prime contract from an owner, then normally what would be a best practice to try to negotiate with the owner, especially if they're a governmental agency, when oftentimes they say you cannot mark up our prime contract? What would be a way to you think to handle that? So
you're right. On government projects, the chances of you negotiating that indemnity provision it's small. It's very small. It just doesn't really happen. And so the key takeaway from that is understanding what you're signing up for, so that you can assign cost associated. You can allocate for that risk. And if you don't know what you're signing up for, you can never include money in the contract amount to cover that risk. And so, or you can't decide I would rather know what I'm signing up for. Right. And understand it and say, all right, I'm gonna make a business decision here. This is worth this risk. Or say, no, I don't have enough money in this project. This one isn't, worth it. It doesn't make sense for me to sign up for this risk. And so that's what on the public projects, that's usually the approach is, okay, I can't negotiate this, but let's see if it makes sense. And understanding that is part of it, not just bidding the plans and specs.
That's good. That's good. I think a lot of us get caught up into that, where we forget about the risk side, because we never think something's going to go wrong. Right. And then it does.
And then it does. And then on these larger projects, I mean, nobody wants to willingly reach into their pocket and pay these large damages claims or sums of money or losses that can incur on a project. And so, other provisions that I see, no damages for delay. Oftentimes, there's delays on projects, and they'll have these provisions that say, you're only entitled to an extension of time. Well, you can incur a lot of cost associated with the delay. And so if you're only entitled to time, what happens to the cost that you've lost?
Can you give us like an example of that specific provision? So I want to make sure everybody understand, what does that mean? So you're saying that most contracts, meaning prime contracts, will say that we cannot claim for additional costs?
Well, I won't say most, but there are many contracts that include a provision that says something along the lines of, if you are delayed on the project, even at the fault of others, your solution to that problem is a request for an extension of time. meaning you get to extend the contract time, but you don't get to recover the cost associated with that delay.
That's good.
And so
okay,
that is something that you would want to know about going in, you know, especially if you are a sub on a project with a whole bunch of other subs, or, you know, you're going to be working with a bunch of other subs, like the drywall guy who's got to depend on the plumber, the electrician, you know, the framer, all of those to work in connection with each other just so that they can do their work. If you're delayed in any aspect of that, then all you get to do is say, oh,
my contract gets extended for the amount of time I have to complete the work.
Right. But if you have general conditions on the project, porta potties or whatever, you're not recovering that.
Right.
You know, and even if it's another month that you've incurred for that.
Right. Unfortunately, I have a contract written like that right now. I hate it.
Yeah. And so that's stuff you know, going into the contract, that's what you want to be aware of, you know. And not all contracts have that, you know, some of them, you know, say you can recover for that, but you want to know that going into it. You know, time of completion, you know, how long do you have to complete that contract, and what are the liquidated damages associated with that contract? Many times we'll see $500 a day for liquidated damages. You want to know that going in so that you can make sure that you can complete that work within the time that's required, or request additional time so that you don't incur those damages during the project.
Gotcha. You know, something that comes up quite often, most contracts that I've seen have been specifically identifying substantial completion as the cutoff time. Other contracts may define what is substantial completion. Now, I don't know this. Maybe you can help me. Is there a Florida statute that talks about substantial completion, or what normally defines substantially complete?
Substantial completion, the universal definition, is when the project can be used for its intended purpose.
Gotcha.
And so on many contracts, you know, you bring up a really good point, because if you're dealing with an owner or an architect that is unreasonable and that is not going to issue you a substantial completion, you know, for minor things,
punch list items,
for punch list items, you know, that can be very costly, because they're going to withhold monies, you know, for liquidated damages or whatever, for you going past that substantial completion deadline for what might be very minor issues. And so from that, you know, the takeaway is, who am I working with?
Right.
Do I have experience with this person? Do they have a history of being unreasonable? You know, that's key.
So what would be some maybe strategies, right, that we could use if we're in a situation where we believe we're substantial complete? Or maybe, now think about it, being proactive as a general contractor or a subcontractor is, should we provide some type of notice that we're substantially complete, or what are your thoughts about
usually
that?
The contract will spell it out. You know, once the project reaches substantial completion, the contractors to provide notice to the architect or the owner. Owner comes out, inspects that work. You know, usually the contract aside, you know, talking nuts and bolts here, it's a relationship. You know, that's usually, if you've got a good relationship with the architect and the owner, you've been responsive, you know, you've got that good rapport, you've got a history of working with them. A lot of times stuff like that doesn't tend to come up. And so, you know, that's why I say it's really important to know.
Have the right relationships.
Have the right relationships and establish that relationship, and keep in constant communication, and, you know, document your paper, you know. I say this in our world, it's not about what you know, it's about what you can prove. And so keeping that.
Ooh, you just opened up a whole nother can of worms. It's not what you know, it's what you can prove.
And so
receipts.
Does that answer your question?
Yeah, definitely answers the question. I think sometimes, and I have to admit and be transparent, sometimes I actually forget to send a notice that we're substantially complete, until then I start thinking about, I need a bill. And sometimes I can't bill until I've identified substantial completion. And sometimes, to your point, the definition of substantial completion that the space is ready for use or can be used for its intended purposes, that may often mean I need to receive a CO, a certificate of occupancy, or a certificate of completion from the authority having its jurisdiction. So whoever I pulled my permit from. So that's another thing that I think is a best practice that many of us need to incorporate, that when we see that we're getting close to the end, we've completed all of our inspections, let's go ahead and call in that final inspection, get that done so we can get our CO or our COC. And then now we have, as you said, the receipts.
Receipts, yep.
We can prove we have paperwork. We're done. This space can be occupied. Here you go. So I think that would be a great strategy to kind of push back against clients that want to use maybe a punch list, or we didn't paint everything, right? You know, like, no. So that's a great strategy.
Okay. A few others, you know, your price escalation provisions, you know, the supply chain issues have kind of slowed a bit, but you know, the market, I think 2020 showed us how important, you know, price escalation provisions are. And it's essentially a provision, you know, the way we write them is that you would be entitled to a change order if the price on the project increases by 5% or more. You know, there's already an understood agreement between the parties that you would be entitled to a change order for that price adjustment. You know, obviously the owners are going to want you to provide backup documentation and whatnot to support that price increase, but you're not fighting, you know, you're not locked in, you know, because we're still litigating cases where, you know, they have gone into a contract, they lump sum contract for, let's just say $100,000, and their material prices went up 50, 60, even 100%. And they're locked in a contract at 100,000 with the cost are 150,000, you know? And so that price escalation provision, had some of our clients had that in there, would have entitled them to a change order to adjust the contract for that price increase without, you know, getting into an argument. No owner, once after the fact, is going to agree to that. They're going to say, you agreed to $100,000, do the work. And so that's important. And then how disputes will be resolved on the project, whether it be through litigation or through arbitration. Is there a pre-suit mediation requirement? You know, I said it before, these projects are becoming more complex. There are more parties involved. Disputes are bound to happen. You need to be able to resolve them quickly to, you know, really protect your profits on that project. And so those are often provisions that we, you know, when we're reviewing a contract, we really go and look at those and sort of audit those provisions.
Right. I know there's a common statement. I'm not sure, you being an attorney, you've heard this before, but a lot of us out here in the industry, we say this: when you get into a dispute, nobody makes money except the attorney. I don't know if you heard that before, but
it's a common saying within, you know, and quite frankly, you know, my goal, you know, I'm a contractor at heart, and sure, it benefits me to provide legal services, but to the extent we can help you stay out of trouble, that's the goal. That's a goal for everybody. Nobody wants to be in a costly dispute. These disputes are very expensive. You know, it's just, it is what it is. And so to the extent you can avoid it, you know, with maintenance up front, you know, talking to, you know, some sort of, you know, board certified construction lawyer or whomever, you know, up front, so that you understand what you're getting into, you can avoid a lot of this.
Okay. So I just thought about something. When we encounter disputes, first of all, we should identify, I think, two things I heard you say. Number one, did we fulfill our obligation to this contract, right? And then maybe number two, did we provide notice? I know most contracts state that if we have a claim, whatever that claim is, we have to provide some type of notice, written notice mostly, to that particular client on whatever that issue is or whatever that dispute is. So before we go down the road of, you know, standing our ground on whatever position we're taking, feeling that we've been harmed or suffered some type of loss, Are there any other things you can think of that we should be doing to kind of make sure we're prepared, to put up a fight for our claim?
Absolutely. You bring up a very good point. Most contracts have what's referred to as a claim provision that, will say, within 7 days from you noticing a claim, you must provide notice of that claim to either the contractor or the owner, whomever you're contracting with. And then they'll usually say something along the lines of within 30 days of you providing notice, then you must provide the backup and the cost associated with that claim. In our world, those claim provisions are strictly construed. And so
what you mean?
Meaning if you don't provide notice, it's a potential waiver of that claim.
So that means you just gave up your rights.
You just gave up your rights because you simply didn't provide notice of the claim within 7 days. And in most contracts, it'll even have a location to where notice is to be sent and a person to whom that notice is to be sent. And if you don't follow that, I can't tell you the amount of times where I'll hear a client say, oh, well, I gave my notice to the superintendent. Well, the contract says you must give it to X,
right? And
he's the project manager, or he's the principal of the company, right. And you didn't do that, and now they have an argument that you waived that claim. And so, something as simple as just following the roadmap, the contract,
right,
it can save you a lot of heartache, and that's something that's often overlooked. So you bring up a good point in that.
Awesome. Everybody say thank you, Roscoe. Thank you. Come on, y'all, say thank you, Roscoe. He just saved you about $100,000 right then.
So and then once you get in the contract, you really want to pass the risk downstream. It's all about shifting the risk. If you're the prime contractor, you've got all this. You signed up for a lot. And so you want to the extent you can, shift some of that risk down to your subs. If you're a sub, you want to shift it down to your subs. Mm-hmm. It all flows downhill, if you will. And so to do that, most prime contracts will incorporate, or a GC subcontract will incorporate the terms of the prime contract into the subcontract.
Okay.
And so if you're a sub, you want to do that too. You want to incorporate your terms into your subs term, into your subs contract.
Right.
A big one is, contingent payment provisions. I'll touch on that in a second. Your retainage provision, it sounds simple, but, most projects, the owner is going to be withholding retainage from you. But oftentimes I'll find these subs aren't withholding retainage from their subs or suppliers. Now, suppliers is a little bit tough.
Yeah, it's almost impossible.
It's almost impossible, but other subs, they're not passing that. So what are you doing? You're financing the project, which is not what you want to be doing.
Okay.
And then I mentioned this before, paper in the file throughout the project, documentation, and writing that documentation in a way that thinking about, if something goes awry on this project, how will this document be looked at? Am I admitting fault in this document, even if I'm not at fault? And thinking about that stuff, because, at the end of the day, when the disputes do arise, all those documents and things on that project will be discoverable, meaning, the other side will have an opportunity to review those documents to make their case and you to make your case. And if you've got an email saying, hey, I totally messed up here and this is all my fault, what do you want your attorney to do with that?
Right.
And so paper in the file and in a good, smart way, is really helpful throughout the project. Contingent payment provisions, I touched on that. The pay if paid language. Courts generally strictly construe those contingent payment provisions because they really shift the risk of non-payment to the sub or downstream. And so, that they really look at how that language is drafted. And, something as simple as if versus when will change everything. And so you want to make sure that, if you're going to include a contingent payment provision, which is, I think that's, recommended. Each contract's different, but most contracts have the contingent payment provision. And so you want to make sure you've done it correctly and you have that conditional language. if, we will pay you if we are paid by the owner. And courts, generally look at that language as it's got to be in clear intent by that party to shift the risk of non-payment downstream.
Okay. So let's say we're on the flip side of that coin, meaning we received a contract that had that provision, but we necessarily do not want to assume that risk. What would be some strategies around maybe how we would negotiate the term of that clause?
So your question is, if you haven't executed or you've already executed,
have not executed,
have not.
But we want to maybe negotiate that language, because I know I have some subcontractors in the room that may be thinking, well, that's why I'm oftentimes struggling with cash flow, because I'm waiting on this payment all the time. So in contrast, I'm thinking of those that are in the room that actually will be operating as a subcontractor that necessarily don't want to assume that paid, if paid, or paid when paid. What are some maybe tools or maybe some language we can use that will possibly be like a win-win for everybody? Any thoughts on that?
I mean, that's a tough, because it kind of is what it is. You could obviously strike the provision altogether, mark it through. A lot of subs do that. And, contractors need these subs, so they're willing to agree,
right
up front. Or you can include some additional cost associated with that project for that provision.
Now, see, that's a gem. I think you all just missed it. I think, now, let me stop, Roscoe, because I'm not sure if they got it. Do you all want this information or what? Do y'all want it? I can't hear nothing out there. Do you all want this information or what? Now, I think Roscoe just chimed in on something key. If you do not agree with the provision or the clause, you can strike it in hopes to negotiate that they really need you, or your price was low and they want you on the job bad enough that maybe they'll figure out a way to negotiate that with you. So 2 points. I think having this conversation, especially with a repeat client, having that conversation prior to even pricing or bidding the job is critical.
Right.
That you have that conversation, or place it on your proposal saying that, payment terms must be X, whatever you would agree to, right? So at least you have given them some warning, some, advance notice that that clause is an issue. The second thing I like about what you said, if a paid when paid or paid if paid clause must be agreed to, please add X number of dollars to my price.
Yeah.
And I think that is another way where now you place the GC in the driver's seat to decide.
Right.
If I want to get the best price, now I have to make sure I pay maybe faster.
Yeah.
Versus, you follow what I'm saying?
Yeah.
So I think now they have to decide, okay, if I really want this contractor, now I need to figure out what's going to work best. And then at least you have something to negotiate.
100%. Yeah. That's, knowing is half the battle, right?
Yeah.
And you go into that contract and negotiate it. You don't have to take on that project.
Right.
It might look great on
right.
numbers wise, but when you start peeling back and looking at this stuff, that's what, the savvy construction companies, they're looking at this stuff and making business decisions based on risk and, how much profit and the owner and that sort of thing. And that's the mindset of successful contractors.
That means you have to be a CEO.
You have to be a CEO.
All right.
And so, I touched on, paper in the file, writing your RFIs, your emails, that sort of thing during the course of the project. If you're being delayed on the project, don't wait past the 7-day notice period. If you've encountered an issue, put it in writing. I can't tell you the amount of times I've heard, well, the project manager agreed that we would, be entitled to a change order. Well, the contract says all changes must be in writing. Did you get it in writing? No. What do you want? That's a tough spot to be in, and so you've signed that contract for a reason. All
Right.
all the parties have an understanding as to what's expected under the performance of that contract. And so paper in the file goes hand in hand with understanding the contract. You've got to meet those requirements of the contract to be successful in your claim recovery.
Gotcha.
Collection strategies. We touched on this, the notice requirements. I'm not going to continue on that, but some of these are just some things that some contractors do. Every, business has their own preferences as to how they go about their collection strategies, but, emails, phone calls. I can't tell you the amount of times I've heard a contractor say, well, I was afraid to record a lien because I didn't want to make them upset, or,
Right.
I mean, the statutes are the statutes, and the statutes, and we'll touch on that. But, those are all avenues to further the likelihood of you collecting on that project. And whether you collect on that project is whether you'll be profitable on that project. And that's what you're in business for. And these are business decisions.
Roscoe, I want to touch on that for a second because, man, you hitting on some great stuff. Sometimes I've noticed for myself, what I realized was there's a personal issue in me because what's keeping me from wanting to protect my business? What's keeping me from wanting to protect my company from failure just because I don't want to upset my client? Like I had to recognize, Roscoe, that there's a personal, deep down underlying issue that I have to work on as a CEO to recognize what is it that's keeping me from filing a notice to owner or filing a notice lien or a notice of non-payment, right? That we sit here and we suffer in silence oftentimes. And so what I come to realize is that we all have to do that work. And I'm not sure what it is in our community specifically, whether it's wanting to be accepted, fear of being rejected, afraid that I did all of this work just to get this client and have this contract, and now I may not get it again.
Right.
But I recognize I had to do that personal work, and I continue to do that personal work because sometimes I realize I just care too much about the relationship, but I'm not caring enough for the sustainability of the business. Does that make sense?
That makes 100%.
So I want to challenge those that are listening to this, that we all have to position ourselves in a way to think in terms of the business first, and then allow what they say, the chips fall where they may, because if someone really cares about the relationship, they want to see you succeed and they want to see things work out. And I think that's really what's important. And when you notice people are not taking care of you, they're not staying true to the agreements that's been made, then you know that's probably not a good relationship.
100%. You've got a huge responsibility as a business owner. You got to pay payroll. So you've got to make smart business decisions.
Awesome.
And recording liens is definitely, a good, practice, because they're statutory. If you don't record them within 90 days, you lose the right to do that. Right. And they're usually, very, very effective in, getting paid on the project. Restructuring your contracts. We touched on this. There's a lot of contracts we'll see where where payment will be due at 50% completion, and then upon 100% completion, you get final payment. Mm-hmm. As a business owner, that means you're financing 50% of that project. To the extent that you can negotiate faster payment terms, you should that should be, money in the door should be the.
Okay.
And so restructuring, if you're a sub, we talked about this, negotiating those pay provisions, limiting retainage, the amount of retainage being withheld on a project. Many of the private contracts have up to 10%, retainage all the way through completion of the project. If you can get that lowered to 5 or 2.5% or whatever, that's something you do up front. You negotiate that so you're not financing 10% of the project.
Right.
and then just understanding, who you're dealing with, who you're contracting with up front really is a benefit. We touched on this, the lien. I'll just give you a little bit more substance as it pertains to the lien. So, usually the lienors under the statute are the contractor, the subcontractor, subs, and material suppliers of any of those, along with laborers. Obviously, architects and design professionals have lien rights as well, but third tier subcontractors do not, and so that's important. And so your parties with lien rights are going to be your contractor, your subcontractor, your subcontractor, material suppliers to any of them, and your laborers. Your design professionals will also, have lien rights. And, the important aspect of it is that, as a contractor or subcontractor, you want to first, provide the notice to owner. What the notice to owner does is tell the owner, hey, I'm actually performing work on your project, and so you want to do that within 45 days from the date you first perform work on the project, from your date of first work on the project. Now, if you're in privity of contract with the owner, like if you have the contract with the owner, the NTO is not required. But if you're a sub, it basically tells the owner, hey, I'm out here doing work on the project, and you need to make sure that I get paid. Okay. That 45-day deadline is strictly construed. If you don't serve that notice to owner within 45 days.
Now that's Florida statute,
that's
right?
Florida statute.
So it could be a little different in other states.
Yeah, other states, yeah. I'm talking specifically Florida here. Okay. This is only Florida. And then in Florida, 90 days to record the claim of lien.
So if you have a claim of lien, you have 90 days from what point to file that lien?
90 days from the date you last performed work on the project, and what we refer to as hammer and nails work.
Okay, so not punch list.
Not punch list stuff. It's physical work in performance of the contract.
Okay, so how would I prove that that was my date? Because I'm assuming if someone was to protest or push back on the validity of my claim, I would assume that they would want to contest the actual date.
Yeah,
right?
And they usually do. And usually what we'll find is, email correspondence that says, that reflects that they were out there, daily reports that reflect that you were on the project performing. I had 6 men out here.
So that's why it's important to actually have your daily reports recorded in a way that actually shows in detail what you were doing on the project. And I know some of us, and I have a particular superintendent I can think of that likes to be very general and it not detailed with what happened. And so now you may be in a position where you're losing that information and that receipt on, hey, we were still working on this date.
Right. Mm-hmm. Yep. Photos help too.
Okay. Photos.
Any documentation that, the takeaway is have some sort of documentation. That's what I mean by paper in the file, and having that sort of daily report that's in detail. Hey, we're out here installing block on X date, and then not waiting until the 90th day, getting that done timely. I can't tell you the number of times, someone will come to us on the last day, and there's all these different questions that we have, about, what kind of work were you doing? How much was it change order work? Was it work under the original contract? Were those change orders signed? All of those play into whether or not, you have, lien rights. And so the takeaway is don't wait until the last minute. Right. Document what you're doing. And, usually, if you're going to be paid after 30 days, you got an additional 60 to record that claim of lien.
Okay, so you brought up a good point. So I heard you say something about even if it's change order work, and you asked, well, was that change order actually issued as an official executed change order, right? Mm-hmm. So maybe it's not an email or a text, even though sometimes we assume that that's good enough. Let me ask you first, is that good enough?
An email or a text?
Yeah.
Depends on the contract.
Depends on the contract. So if the contract specifically states it has to be an executed
change order in writing, signed by.
Right. That means it cannot be an email or a text.
They're going to be obviously attorneys are going to argue on both sides of that. The parties waived that requirement based on their prior conduct, or there'll be some sort of argument, but you don't want to be in that position. You want to follow the contract to limit any arguments that you're not entitled to that change order.
I think a lot of us get in trouble with that piece. I've been there, done that. So got the t-shirt too for that, because sometimes we're in situations where we're trying to maintain the schedule. We're trying to ensure that something that had to happen on a specific date, right? And if we miss that date, the entire project is delayed, or it could have some significant implications, right? So some of us with the good heart, right? Yeah. Thinking about the best interest of not just the client, but maybe the end user, that we're thinking, okay, we got to get this done. Send me something, right? So we have some type of documentation. I think that's where we fall into that trap, where we don't follow the provisions of the contract. So back to the payment piece. If we don't, let's say, for instance, there's no specific provision on how a change order has to be issued. There is some type of mutual agreement via email or text message that states that, hey, yes, I will pay for this additional cost, additional scope. So I know sometimes that may adjust or may not adjust the timeline. If, let's say, for instance, we bill for that work, they don't pay for that work, are we still tied to just the end date based on the time we worked, regardless of the scope? What if we pulled off the job and then came back? Meaning we demobilized and remobilized for change order work or something like that.
So, it's very fact specific, but, generally I would look at what the emails reflect and whether you are actually, how the impact of that change, what impact was that change order on the overall schedule, and argue, we're entitled to X amount of days for, additional time for this scope change. But, in practice, what you should do is say, this is going to be an additional 21 days of work that we need to add to the schedule, so that there is no trying to argue and trying to piece together, you left the project and came back on this date. And it just you could see how it makes it more complicated. And ultimately it's going to be a judge or a jury or an arbitrator that's going to be looking at these issues and their people. And so if you're having trouble, justifying it or coming up with that number, someone else might. And so putting that in the paper and identifying, okay, this is a change. And that's a common mistake, they'll not requesting additional time for the change order, just getting the amount. I mean, that's not enough. It's not enough. If it's going to impact that schedule and that completion date, and you're going to incur liquidated damages and whatever, you need to identify, in that email, how much time you need.
Right. Right. And then as far as the payment, if I'm filing a lien saying I haven't been paid for change order work, is, let's say I don't have an executed change order, but I submitted it, I filed a claim for it, but I'm trying to file a lien on the amount of money I had not been paid for change order work. Would that lien stand up?
Depends, obviously that is we would have to literally look at your contract, look at the facts, and make a business decision. We'd say, look, this is I think you have lien rights for this, or I wouldn't lien for it. And sometimes, we go back and forth as to whether or not, it is lienable. In many circumstances, we find that there is substantiating documentation that shows the parties agreed to that additional work. And it'll depend on which area in Florida you're in as to, what law, what the appellate courts say about, change order work and that sort of thing. But, it's a very fact specific question.
Okay, so my two last questions I have on as far as getting paid on government work. Oftentimes we cannot lien the project.
Sure.
So what would we do in that case?
So on government projects, you're required most of them. You're required to almost all of them. You're required to have a bond unless it's within a certain dollar amount.
Let's say it's not over the requirement. Let's say it's under the requirement for a bond. What would I do?
Then you can't lien that project, and you're relying on the strength of the public entity.
Mm-hmm.
And so the key is making sure all your change orders are executed. Now,
Mm-hmm.
on public projects, you're not going to be making claim. You can. There's some case law that says you can make claims for additional work that isn't executed, but there's all these different sovereign immunity defenses to work outside of the original contracted scope of work. And it's going to really depend on, what that additional work is as to whether or not you can recover. But on those smaller projects where bonds are not required, you're essentially relying upon the strength of that public agency. On the projects where the bonds are required, which are most, I think I believe the threshold is 250,000. So it's, most public projects are greater than that. You're required, the contractor is required to have a bond. And so you would want to, perfect your bond claim. The bond's required to be recorded in the public records with the notice of commencement, and you would have the opportunity to make a claim against that bond instead of recording a lien. Now, if you're a sub, then you'll need to send the notice to contractor, which is essentially like a notice to owner, upstream. And then you would need to, on a private project, you would need to send a notice of non-payment. On a public project, if you are in privity with the contractor, you just file the claim against the bond.
Okay, file a claim directly against the bond. Do you still issue a notice? Either way, you will still issue a notice prior to actually filing against the bond?
So on which project?
Either one.
So it depends on a private project.
Okay.
If you're a sub and you're in direct contract with the contractor. Then no, you don't need to. You have to file suit within 1 year from the date you last performed work.
Wow.
If you're a sub, you do. You need to send that notice to contractor within 45 days on a public project to the contractor. And I always send them upstream. It doesn't hurt to everybody upstream. And then file suit within, file suit within a year.
Okay.
From the date of your last work. It's different. If it's a lien, it's a year from the date you record the lien. If it's a bond, it's a year from the date you last performed work.
Gotcha.
And so
basically you have more time if you're filing a lien, but if you're filing against a bond, it's usually a little bit less time.
Usually a little bit less time. Yeah. And that's something that people overlook quite frequently. On private projects, the notice of non-payment is required even if you are in privity with the contractor. That's something, a little bit of a nuance. On public projects, the notice, like I said, it's not required if you're in privity with the contractor. You just file suit.
Okay.
And one thing I do want to add too is, these are, very liens and bond claims can, really be messed up. And so, my recommendation or, word of the wise is to seek counsel to kind of help you, put those together. One other thing with the notice of non-payment is you want to make sure, you're not just sending that notice of non-payment to the contractor, that it's actually going to the surety too. So that the surety doesn't have a defense to your claim saying they didn't get receipt of that.
So how would I, if I'm a subcontractor, how would I actually know who the surety is? How would I find out that information?
You'd go to the notice of commencement, and if it's not recorded with the notice of commencement, then you would request a copy from the contractor, and you would have 45 days from the date that they provide you with a copy of the bond.
Okay. So let's say, for instance, the contractor, they know we're having issues, right? They know that maybe I may have a claim, or maybe I haven't been paid, and I request this information. I think, first of all, it's best practice to ask for this at the beginning of the project,
Sure,
because it's always easier to get it up front.
Yeah.
But let's say I didn't, I forgot, I didn't think about it, didn't think it was going to be an issue. Now it is, and I request it, but they give me the runaround.
I'll go to the public records and I'd search for the bond.
Nice. So we can actually look up that information ourselves in public records and actually do a discovery and find it.
Right, because they have to record it in the public records.
Say thank you, Roscoe. Right?
Yeah. And you know, on private projects, you know, you would request a copy, and the statute says within 45 days from them providing you with that copy, then that's when the timing, you know, triggers, if you will.
Gotcha. Awesome. So I have a situation with a person that was on one of our lives recently, and she was saying that she's doing some healthcare work and has a client, actually it's a contractor that she's working for on a hospital project up in New York. So I know probably law is totally different there. But she hadn't been paid in 9 months. And I thought that was weird. Like, it's very rare that we hear things like that. I know I had that situation that you helped me on with a particular client because there was no bond in place and they held payment. And I know there's certain situations like that that may come into play. But I thought for 9 months or even 6 months, that's like an extended period of time. What would be your advice to anyone that's out there listening that's running into like extremely delayed payments? What would your advice be?
Sure. You know, obviously this is for educational purposes only. I'm not barred in New York, so I'm not speaking to New York, and you know, all of everything that I'm saying is general information for educational purposes. But you know, usually when it gets to that point, there's something going on. And at that point is the time to start gearing up for, you know, a dispute. I think even before 9 months, you're probably needing to seek counsel, or at least, you know, get to the bottom of what's going on. If you haven't been, I mean, no contract says, you know, at least I don't know that I ever seen one that says you get paid at the end of the project.
Right.
You know, it's usually 30 days. And I'm guessing she's submitted payment applications and done what she's needed to do on her end.
Correct.
And you've just got a GC that's just not paying. And I'm sure, you know, New York probably has some sort of, you know, lien statute, but I don't want to speculate. I'm not barred in New York. So, you know, my advice would be to find someone who is barred in New York, who is experienced in construction issues, and to consult with that person. And because usually at that point, that's where it sounds like that's where it's headed, is, you know, a dispute, even a dispute as to interest owed, you know, if nothing else, if that's recoverable, you know, and so.
Okay. Is interest owed Florida statute here, or does it have to be a provision in the contract before you're able to collect interest?
It will depend. It will depend on what New York.
Well, let's say Florida. Let's say in Florida, do we have to add that provision in the contract for interest for late payments, or is that part of the statute that we're able to collect interest for late payments?
You should add it into your contract
if we can.
If you can, and then we'll try on the back end to.
It's more of a negotiating tool, probably. Then it's
hard to get that if you haven't already included it in the contract. We'll make arguments. We'll try to get it, but you know, the takeaway is negotiate that in the contract, and usually, you know, it's something reasonable. You're not trying to make a living off of interest. You know, it's got to be
Right.
Can't be usurious. It's got to be a reasonable amount.
Right.
And so.
Awesome. Well, listen, Roscoe, thank you so much for being here with us today. I know there was an invaluable amount of information that was shared today. And if you're out there and you're listening to this, I know that it's important for you to prepare yourself, get ready, but don't forget what I said earlier. Do that personal development work as well as making all the best practices in your business, making sure your staff is on top of what Roscoe said, paper in the file, to make sure you have the receipts in place. So if you ever have to file a claim, you ever have to go into the dispute, that you're ready and that you're prepared.